South Africans, I greet you all. And once again, I am humbled to be addressing you in this particular platform. And then I would like to take you quickly to what has happened in the Western Cape High Court in relation to the matter that one was waiting for the whole week last week. So, without wasting any further of your time, one has received an email yesterday from the court, and then such an email had a court order, and then I will take you step by step for this particular matter and then give you exactly what had happened in this particular regard. So the court order is as it appears in front of you right now in the High Court of South Africa, Western Cape Division, Cape Town, case number 19275 of 2020, Cape Town, Wednesday, 31 August, before the Honorable Miss Justice Mangcu Lockwood. And it was written at this party. The parties are myself as the applicant, and the Minister of Defense, the first respondent, the South African Human Rights Commission, the second respondent, the South African Broadcasting Corporation, the third respondent, the CLC Propriety Limited, the fourth respondent. Order delivered via email 31 August. So now, before I take you to the order, I just only want you to see something. This is an appeal that was lodged. The case number to the appeal is 15141, and the respondents are in this particular form. Look at this. The case number there is not as per the appeal. You understand? In fact, this particular case number is not talking to these respondents. This case number is talking to all these particular respondents, because the case number 19275 of 2020 is all these respondents, including the National Prosecuting Authority as the third party. Now, we are having a reality where we have a misrepresentation, and effective immediately, every single thing that would be said henceforth is unlawful, unconstitutional, and invalid. That is what you need to understand. Because to waste your time and then say, hey, we can now continue and past begin, is basically to waste whatever people's time. So get good people. The reality is that this is what had happened, and then this is the first thing that one needs to sort out before we go anywhere else. Misrepresentation is serious. Remember that one is currently sitting at home without a salary simply because of misrepresentation. Do not take things lightly and then think that everything is okay while everything is not okay. Misrepresentation, it is unlawful, unconstitutional, invalid. And good people, I want to share with you what the judge has said and what, but it will be wasting your time, and then it will be scaring you, and then whatever that the judge has said, to be honest with you, is not good, even if it was good, because this is done in my name, and I am doing things in accordance with the Constitution and the law. This is what must be corrected. I must not be misrepresented. I must not be lied about on my name. It starts there, it ends there. Simple as that. So, fellow South Africans, I am busy having the matter constitutionally reviewed, and then I will set it down requesting the Judge President or the Deputy Judge President of the Western Cape High Court to grant a full bench to hear the matter. I'm tired of listening to one judge who fears the other judge who is unable or incompetent to say, yes, Mangolele was there, and 14 September 2018, yes or no, he was not there. The reality is, this particular matter, as you all know it, is that the first point that needs to be proven by the state is whether I was heard or granted an opportunity to be heard before the matter was the order could be granted. Let's not dilly-dally. Here is the Vexatious Proceedings Act. Whether after hearing that person or giving him an opportunity of being heard, only then would the court order that the proceedings shall be as it is ordered. This is the key point. This is talking in terms of the Constitution and the law. This is the law leading to vexatious proceedings, and then that is exactly that. Now, given this particular reality, you would know me not to waste any further time in relation to what needs to happen. I am busy writing for this particular case number that is being misrepresented in relation to its defendants or respondents. I am saying to the court that, listen, the matter was not heard on 26 August at 11:30. Only case number 15141 of 2018 was briefly heard as represented, attached here to marked SVM 27. However, misrepresented as attached here marked SVM 28. When we go to SVM 28 and SVM this thing, I am accurate, good people. SVM 27 is this when the court sent this particular email and said, as per yesterday's hearing, judge said that she will communicate with you yesterday, but judge will communicate with you next week. You see what the judge was going to communicate about next week in this particular regard. So these are the things that one needs to take into account. That is SVM 27, and then it is now misrepresented as SVM 28, where it is now case number 19275 of 20. You understand, the same thing that I have shown you and stuff like that. And with it as it is, I am saying the plaintiff has constitutional guaranteed to just administrative action, whose source is section 33 of the Constitution, which provides that everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. Procedurally fair, it brings us back to this particular procedure, the Vexatious Proceedings Act. Is this procedure, was this after hearing that person or giving him an opportunity of being heard? Is it being done, yes or no? You find that it is no, because I was not present in Cape Town on 14 September 2018. I was in Pretoria. So it doesn't matter who I was with in Pretoria or what matters is what the law says. If the law says that person must be heard or giving him an opportunity of being heard, that is what must happen. It must be done by all people, regardless of race, color, gender, ethnicity, culture, or sexual orientation. That is what they must do. You get what I'm saying? So without wasting your time, I have said that this is a constitutional obligation. I'm teaching you this such that you know how these particular things are done, and then what am I referring to, and then what informs this particular papers and stuff like that. So quickly, in terms of section 33 of the Constitution, it is exactly as it is, and you cannot redefine the words of the law to your own choosing. You must say the words of the law the way they are. You don't do your own thing. Just administrative action, it is that. You understand? Let's come to this just administrative action. Yebo, where are we now? Come here. So when you look into this particular thing here, this is what happens. Everyone has a right to administrative action that is lawful. Everyone has a right. It's direct copy and paste. Remember, I'm acting in accordance with the Constitution and the law. Acting in accordance with the Constitution and the law, it is exactly what you must do. So, national legislation, everyone has a right to whose rights have been adversely affected by administrative action has the right to be given written reasons. And national legislation must be enacted to give effect to these rights and must provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. Impose a duty on the state. The state in this regard is the first defendant. You understand? Impose a duty on the state. There is the state, your first defendant, and then to give effect to the rights in subsection 1, 2. The state must give effect to these particular rights. Procedurally fair issue, and then written reasons when your administrative action has been done. But before we go to the written reasons, we get to the procedurally fair issue. So that in its own, it has on these grounds that the Deputy Judge President or Judge President are humbly requested to direct a full bench to review administrative action adversely affecting the human dignity of the plaintiff, to provide as a father to Nyeko Mangolele and Aluta Songelwa, provide as head of the Mangolele family, and as a son to the 83-year-old later Kukunana Majila. The grounds for the review by a full bench are the following: absence of jurisdiction on the part of the court, interest in the cause, bias, malice or corruption on the part of the presiding judicial officer or officers, gross irregularity in the proceedings and the administration of admissible or incompetent evidence, or the rejection of admissible or competent evidence. Like when you are rejecting admissible evidence, it's like you are rejecting the fact that I am telling you that in accordance with this particular thing, there is, after hearing that party, this is admissible evidence. And now when for me to be caused to review this particular matter is because you are not taking into account the admissible evidence. You are taking into account what any other person wants to say about Mangolele. Hey, he's vexatious. And vexatious people, it means that a person has instituted legal proceedings against any other person without any reasonable ground. You understand? You must learn to read the law and its meaning without any reasonable ground. So now, is it true or unreasonable for one to be confined into a space where you are living under these particular conditions as explicitly set forth in this particular picture? So Gorewena, you basically don't have any reasonable grounds to say, I want to get out of this particular picture. And to make sure that you maintain, you stay in there, let me, for crying out loud, show you the court order on this particular effect. It says, order in the circumstances the following order is granted. The urgent application of 26 August 2021 is struck off the roll for failure to comply with court order 14th September. You see now, when they say comply with 14th September, that means you must agree that you were present when on the 14th of September in Cape Town. That's why you must comply with it. You understand? It's like here reason does not act, and then people forget that one is in a position where they cannot obey a manifestly illegal order in any event. That is as constitutionally mandated and also lawfully obligated in terms of Section 2E of the Defense Act and the Code of Conduct for Uniform Members. The applicant is ordered to pay cost of this application on attorney and client scale, and furthermore, the applicant will not be allowed to sue in this court as per Court Order 14 September 2018, and he will only be allowed to sue in accordance therewith and after paying the cost of this application as per para B above. And now, good people, that is my Judge of the High Court and Mangcu Lockwood, who says that who basically gave effect to this adverse administrative action. There are many things that she's saying here about the Constitutional Court, where we now being dragged to that matter where the the Chief Justice has judged himself. But I will address this particular judgment paragraph by paragraph. But currently what needs to happen is the interlocutory order that needs to be heard by the High Court in terms of its prayers explicitly set forth on court record. So, to cut this whole thing short, fellow South Africans, it is that the order by the Honorable Mangcu Lockwood is unlawful, invalid, and unconstitutional. So, without any further ado, let us let the law take its course in that particular regard. I thank you, Papa O Teng. God bless you. Thank you.